If you operate a business in California, or not, but you employ California residents, don't be fooled by non-compete clauses or non-compete agreements.
My faith rising. I'm crawling out the trenches, holding me.
Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. Y'all, I've been gone for 2 weeks because life was lifing. I've been traveling, I've been working, and something just had to give. But I'm back, and I've got questions to your answers throughout the rest of the year. So today we're talking about the infamous non-compete agreement. And before I go any further, I just want to tell all of my California employers and employees, stop already. In the words of the California Attorney General, non-compete agreements have no place in California. But why? Let's jump right into it. First, let's talk about what is a non-compete agreement. A non-compete clause or agreement is generally a contract that is signed between an employer and an employee at the start of their business relationship. These non-compete terms prohibit an employee from establishing a competing business or accepting new employment opportunities in a similar line of work, usually within a certain geographical area and for a specified period of time. As you can gather from its name, a non-compete clause or agreement prevents the employee from competing against its former employer. Initially, non-compete agreements were intended to protect the business's trade secrets and other confidential information. However, over the years, non-compete agreements have been used by companies to just altogether prevent an employee from changing jobs, which can essentially limit that employee's upward mobility within the workforce. For this reason, non-compete agreements are not enforceable in California. As an employer, you need to be aware of the potential liability that you could face if you try to bury a non-compete clause within an employee agreement, or if you just happen to download one of those generic contract templates from the internet that contains non-compete language. Did you hear that? Of course you didn't, because you haven't subscribed and you haven't hit the notification bell. What you waiting on? You know I'm your legal bestie. Stop playing. So go ahead, smash the like button, subscribe, and hit the bell so you can be notified every time I drop a new video. So as an employer, that begs the question, can my company just have employees sign a non-compete agreement anyway? The employee won't know any better, and maybe it'll scare them a little bit, even if it's not enforceable. And if it's not enforceable, then no harm, no foul. The short answer is yes. You can absolutely include a non-compete clause in your employee agreement, even while knowing that it's unenforceable in California. However, you place your company at a significant risk of a lawsuit for unfair business practices under the California Business and Professions Code. You might also ask, can't my company just draft a non-compete agreement that says that the governing law will be in another state that does enforce non-compete clauses? And I submit to you that that may work in other instances, but when it comes to California's non-compete prohibition, this law expands to any out-of-state employer that even hires California residents. So if you have a connection to California, California law will stand. Additionally, as an employee, if you've entered into a non-compete agreement or you've been presented with a non-compete agreement, you can report that company to the California Attorney General's office. You got to know your rights. But of course, with every good rule, there's also a what? An exception. But you knew that. So last but not least, I want to talk about 3 exceptions to the rule. So let's recap. What's the rule? That's right. Non-compete agreements are not enforceable in California unless You're in a business partnership. When you own part of the company, you're not considered an employee. You have different bargaining power, and you are considered to know a lot more about the intricacies of the business than would an employee. So yes, your partner can enforce a non-compete agreement against you as a business partner to prevent you from competing with them. Exception number 2. You're an owner or a member in an LLC. Same concept as exception 1, just with a different business entity or business structure. And exception number 3. A non-compete agreement may be enforced in connection with the sale of a business or with the sale of someone's interest in the business. In that situation, the parties to the sale can agree that the seller will not compete with the business in the geographical area where the business is already operating or intends to operate and do business. For example, if my friend and I decided to open up a juice bar, and a year later she decides that she doesn't want to work within the company anymore, and I purchase her interest in the business, she can't then turn around and open up a juice bar down the street, or even within the same city. That just makes sense, right? Well, I hope that was pretty straightforward, and that's all I have for this video today. Let me know in the comments what your thoughts are about non-compete agreements. And until next time, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far. I'ma keep it pushing, yeah. Even made it through the